Can you walk us through through what affidavits of heirship is, when it can be done? Can it be done while while the probate process is going? In other words, like, can you file for probate and then maybe do affidavits of heirship to kind of, fast track the process of selling the real estate? Walk us through that.
Affidavits of heirship are a fantastic option if and only if real estate is the only component of the estate. So I'll have people who will call me and they will want to do affidavits of heirship, but then maybe there's some bank accounts or there's a retirement account or there's assets otherwise that affidavits of heirship do not control. So I will draft affidavits of heirship for clients when I know for certain and I double triple check it. Listen, there is no other asset that needs to be probated, then this is appropriate. One of one of the checklists on a good affidavit of heirship is more or less swearing in that affidavit that there is no probate administration that's open. There is no requirement to probate the estate because all we have is an interest in real property and that's it. So generally speaking, it's one or the other.
Got it. Got it. And can you also tell us a little bit about Muniment of Title? What is that? How does that work? What does it mean?
Muniments of title are it's essentially applying to probate a will without opening a formal administration. And it's fairly common for married couples when somebody loses a spouse, or maybe when someone loses a parent and that person who lost their parent has a complete understanding of that parent's estate, knows there are no debts, knows everything can essentially be transferred under a muniment of title. Muniments of title are great when you know for sure that there are no debts to the estate and that there isn't a Medicaid issue, because you cannot use a muniment of title if there's a Medicaid clawback. So if your spouse or your mom or your dad or whoever has passed away qualified for and received Medicaid benefits, I think it's after 2005, anytime after 2005, then you can't use a muniment of title as an option.
Okay. Okay. I want to get into some real world scenarios, kind of like a case study kind of discussion. And I want to start with, can you share a situation where having proper legal guidance saved an executor from a very serious problem? Maybe you can give us a couple of these scenarios.
I think, at least in my practice, I get a lot of people who, and this kind of harkens back to something I had said a little bit earlier. Nobody wants to open a probate administration. Nobody wants to pay a lawyer to do that. People, and this is not a criticism because I do it myself in other avenues in my life, seek the avenue of least resistance, something that costs less than something else. I mean, the world is an expensive place, let's face it. But I'll have a lot of people who will want to use small estate affidavits, which is another mechanism you can use under Texas law. But I very strongly discourage most people who call me to try to do that, because you have to have a concept of all of the debts that the estate has. And most people, really most people, don't have a full understanding of the debt that an estate can have. And they'll want to push through small estate affidavits. And then if you have a creditor or a credit claim that comes through on the other side, you can have an issue. So there's been a few instances where I've advised people to open administrations because I didn't feel like, at least in my opinion, that they had a good enough understanding of the estate debts. And sure enough, as soon as we open an administration, all these creditor claims come through, and it's me reassuring the client of, this could have gone very differently and could have been a lot harder if you tried to push through the small estate affidavit, because we'd be right back where we are now, just with more expenses and more time getting to the same place. So that's an example of it. I have defended clients in the past that have been named as administrators or as executors or as trustees of trusts from litigation from beneficiaries. It's not incredibly common, but it does occur. I don't think there is a good reason not to have legal counsel in that kind of situation, because as a fiduciary, even if you're just a trustee of your parents' trust, there's a lot of responsibility that comes with that. And if you're being challenged by other beneficiaries, missteps can be very, very costly.